Hello and welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legal Bites merch. Again, all links are in the description below. And with that said, let's get into it. All right. Let's get right on into it. Indy, up. There you go, pup. Everybody wants to see you. You're the real star of this show. You and the cats. Come on. Good girl. Oh, and here comes Holmes. All right, you guys. Happy Tuesday. We are back at it with another live stream. Yesterday, of course, was another Menendez Monday with the Eric and Lyle Menendez trial. But today we are in pre-litigation mode. This is a hearing that we are going to be watching and I'll be commenting on from time to time. But this is in the Courtney Clenney case, the Florida versus Courtney Clenney, also known as the OnlyFans Murder Case. To give it some extra pizzazz and spice, of course, as Court TV and Law and Crime and all those others like to do. Give them like these like spicy little nicknames. So this case it's interesting. It's interesting. I wasn't sure if his hearing was going to be worth a whole live stream, but I think it definitely is, because even like right from the beginning, we see the judge sort of like whipping the attorneys into shape. I know that that's been a really big subject in some recent trials, especially the Jennifer Crumbley trial. The judge in that case, I've seen a lot of complaints about the judge in that case not maintaining basically like good order and discipline in the courtroom, and the attorneys are just like walking all over her in a lot of ways. I think this case is going to be different. I think this trial is going to be very different. This judge is showing very early signs that she is not going to have any of it. And she's sort of like training the attorneys in this case very early on. That's at least the sense that I have in this case. And you'll see for yourselves. But okay, so this hearing, what was listed for the hearing was it was a motion to compel, which means that one of the sides was asking for discovery from the other side. They weren't getting what they needed, and that as a result, they were asking the judge to get involved. Now, when it comes to a motion to compel, every single jurisdiction that I've ever worked in is the same, basically. Rules across the board. Judges don't want to get involved in these discovery fights. They don't want to get involved because they're backlogged as it is. They've got all kinds of hearings and other stuff that they've got to take care of. They don't want to get involved in these sort of fights. So when they do get to the stage of a motion to compel, it's after they've gone back and forth a number of times. They've argued. They've basically decided, no, we need the judge to get involved. So that's what this is going to be. But also, this hearing is from like the day after or 2 days after Courtney Clenney's parents were arrested, and TMZ reported that as an evidence tampering case. And so that's what I talked about in my video. And of course, I should have known better. Don't necessarily trust reporting because it's not necessarily going to be accurate. They're going to talk about that in this case or in this hearing. And they're also going to talk about some other issues related to that, related to evidence that the prosecution has and evidence that the prosecution is going to get in connection with these new charges, including one new charge for Courtney Clenney, which is the same kind of charge as for the parents. So, okay. All right. Let's get into it. All right. I don't want to give away too much before we go through the hearing ourselves, but I just wanted to sort of lay some of the groundwork as to what actually happens in this hearing. It's not just like a simple case management hearing where they're like, "Oh, this is we're waiting on this, we're trying to get that, and trying to move towards trial." No, there are some legitimate controversies that are coming up in the litigation here, and also some messaging for the media, which is really really interesting because they know that the court TV and others are in the courtroom, and so there's a little bit of messaging for the public and for the media going on in this hearing as well. And also, yes, thank you so much, Hazo. And if anyone's not familiar with this case, there are details in the description box below the stream. Thank you. But just a quick little primer for anybody who's not familiar with this case. In I think it was April 2022, definitely 2022. Courtney Clenney killed her then boyfriend, Christian Obumseli, in their Miami apartment, or her Miami apartment. I think she technically owned it, but they lived there together. She had stabbed him with a knife. She claimed it was self-defense. The police didn't investigate until months and months and months later, when the Obumseli family continued pressing to have it investigated. And they ultimately did, and found, oh, this is not a self-defense case. This is a murder case. So anyway, so she was arrested, and now here we are. There are so many issues, and everything that has come out publicly to this point appears to be very prosecution friendly. And that's one thing that's also going to be interesting to sort of think about as we're going through this hearing, because that's kind of one of the complaints that the defense has here, is about the media, and basically saying, like, we need to be able to respond, we need to be able to, like, kind of like help shape the narrative, sort of, which there are some limitations for professional responsibility as to how much an attorney can go and make statements to the public and to the media for any kind of a case like this. And we'll talk a little bit about those professional responsibility rules as well when they come up. So all right, that's enough of that. Let's let's do it, shall we? Okay.
Yes, good morning, Judge Frank Padilla on behalf of Ms. Clenney.
Sabrina Puglisi and Diane Premis on behalf of Ms. Clenney.
And good morning, Your Honor, Tara Coas.
Sorry, boosting the sound. By the way, fun fact, for those of you that have been following the Adelson cases, this attorney right here is a brand new attorney for the Clenney team. And she apparently was the attorney for Catherine McBanoa. She's the one who was like the linchpin in the whole murder conspiracy in that case. She's the one that found the hitman. She was the one that was dating Charlie Adelson, who was the brother of the ex-wife whose ex-husband was killed in that whole case. So she's now involved in this case as well.
Right, so we have two matters in front of us today, essentially two matters. One involves a motion to compel discovery, and the other involves a petition for order to show cause, as well as several replies back and forth.
Your Honor, just for some housekeeping issues, if Your Honor wouldn't mind.
Sure.
At this time, in case F22-14137, the state is filing an amended information. The defendant is still charged with second-degree murder with a weapon. We're adding another count of interception of wire, oral, or electronic communications, a third-degree felony.
So I don't know if you guys caught that, but they're adding a new charge. That's for the computer activity. It's not specifically for tampering with evidence. I'm sorry, guys. Yeah, I know the sound is a little bit low in comparison. How about this? I'm going to turn my volume down. I've boosted it as much as I possibly can. This is at yeah. No, that's all I can boost it. So I'm going to turn myself down so you guys can turn it up. I'm sorry. I hate to make people do that, but I think we're going to have to do that. Hang on just one second. Let me adjust myself here. Okay. Maybe that's better. But let me know moving forward if there's still like sound balance issues. Okay, so they added a charge to Courtney Clenney's to Courtney Clenney's case, which was not evidence tampering, but basically like essentially like hacking. It's similar to hacking charges where you're getting into someone else's computer without authorization. That was the act of using a password or figuring out a password to get into Christian Obumseli's laptop after it was left behind from the police, and then ultimately the parents gave it over to the defense attorneys apparently. But there have not at this time been any charges for evidence tampering. You'll hear in the hearing that the prosecution has started to analyze the laptop. So maybe there could be some evidence tampering charges that follow this. But at this time, the charges, and it's still third-degree felony, it's still 5 years that they could be looking at on top of whatever else for Courtney Clenney. But the parents now are looking at 5 years. So anyway, so that's for the act of getting into the laptop.
You want to arraign her on the new.
Can we see it? We've
We've
heard
never
of
been
this.
notified of it. We've never seen it, which seems to be typical these days.
All right, nope, we're not going to have any of that here. If we're going to do any of the inappropriate comments or grandstanding, we're going to hold off on hearing today.
No matter whether
Get that? She's like, nope, none of it. We're not hearing any of that. No grandstanding, no comments, because the defense said, oh, we haven't seen this new charge. This is, but this is typical of the prosecution. Sort of this sort of like attitude about like, you can tell that there's some real frustration about dealing with one another. Maybe it's a bit of, chest puffery. Maybe it's a bit of grandstanding and showiness, but this judge she's very, very serious about it. And she's gonna put everybody to this also by saying no sideways comments.
they look at that also, the state is also filing discovery in the court and handing over to defense a copy of the filing, as well as it's the warrants judge that created the new case.
All right, Mr. Prieto, you did hear me just now, right?
Yeah, I did, Judge.
Okay, so we're going to keep it purely professional, and that includes everybody in the courtroom. So if it's not kept professional, then we're going to shut the hearing down today, and we will do it on another day when it can be professional. Okay?
Understood, Judge.
Thank you. So no throwaway comments.
No throwaway comments.
With
Or
that,
anything.
I'm sorry.
Judge, on behalf of Ms. Clenney, we're enter a plea not guilty, demand discovery, and request trial by jury.
Okay, thank you.
Your Honor, with that being said, we do have an information for the new case. We can address it at the very end, or we can do it right now. It's up to Your Honor.
You can go ahead and address it right now.
All right. So, in case F242015, the state is filing a consolidated information, consolidating F242016, F242169. It is making
Gamer Ducko, good question. Are there closed captions? Yes, there probably are. Yes, there are. Okay. Here we go. I'm so sorry for not thinking about that myself. Thank you.
defendant A, Kim Dwayne Clenney, defendant B, Deborah Clenney, defendant C, Courtney Clenney. We're charging one count of offenses against computer users, third-degree felony for all three defendants. We have provided a copy to defense.
On behalf of the Courtney Clenney, we have not guilty demand discovery and after the case is set aside.
And then for Ms. Deborah Clenney and Mr. Kim Clenney, who's representing them?
Your Honor, Kim Clenney and Deborah Clenney were arrested day before yesterday in Austin, Texas. They were subsequently released. They will be appearing in Miami at some point to self-surrender at TGK. There's a $5,000 bond, so those bonds will be paid and they should be
Find
released.
nothing for them.
Messages I'm receiving. But as of yet, we do not have counsel for them. Due to the nature and circumstances of what the state's allegations are, I don't think that myself or Ms. Puglisi can represent them. So we will get them counsel.
Does Your Honor want to set an arraignment date so
Well, I
that?
think that we need to set it for them to have attorneys and for us to make sure that they are represented. So I'm going to go ahead and set this as I would another case and set it for 2 weeks for court attorney for them to come in with counsel. They don't have to be here as long as the council's filed a notice of appearance, that's fine. We do it the same as we would any other case. So 2 weeks for, so F-24.
2015 A, B, and C.
A, B, and C.
Yeah.
216 for probate money.
And you want the C to travel along with them, Judge, even though it was arraigned?
An arraignment will be scheduled that same day.
All right,
So they're giving it two weeks for the arraignment of the parents. And Debbie Faison Cook, are the parents in Florida yet or still in Texas? As of this particular moment, I'm not sure, but at the time of this hearing, they were still in Texas, was my understanding. Or at least they had not yet surrendered themselves to the authorities in Florida. Let's see. Was there also another question? I don't see it. Okay, let's continue.
so then let's go back to Ms. Clenney's case. For the motion, we're going to start with the motion to compel discovery, because I think that that's going to be potentially more straightforward, but we shall see. All right, so this is the state's motion to compel reciprocal discovery based on some things that have been turned over, some things that have not been turned over. So let's discuss what you are seeking at this point.
Judge, the rules of discovery are clear that the defendants have an obligation to, just like the state does, to affirmatively provide discovery within 15 days. There are, among those witness lists, reports, statements that are made by those listed witnesses. Some discovery since the state's initial filing in December has been provided. We received the video that we were requesting for over 30 days. That video was removed, had audio removed. There's clear communications in the video. Those are statements of those people. We are entitled to that.
Yeah.
The defense, for example, yesterday amended discovery listing witnesses. That's perfectly fine. I provided the court a copy via email. So again, they just have to provide a list 15 days upon these witnesses becoming witnesses, assuming. So that also is contingent with statements, contracts, agreements. It's anything that would be in theory discoverable. So for example, if they retained an expert, a point of contention might be this person's retainer. This person, you pay someone $1 million, they might do whatever you want. The state has not received any retainer agreements, any kind of contract.
Zero throwaway comments.
Zero throwaway.
I understand.
It's holding everybody
to it.
About discovery as far as experts, but
I was using an example, Judge, of a hyperbolic figure. My point is, and then that wasn't meant as a throwaway comment. It is a question of credibility.
You can tell she's going to hold everybody's feet to the fire. Like, this is not a defense thing, not a prosecution thing. She's going to hold everybody's feet to the fire. I like her a lot.
A witness might be paid, and the state is entitled to that discovery. To date, we have not received that. Similarly to the witnesses that were listed yesterday, the state did not receive any statements that might or might not have been made by these persons. Additionally, and pertinent to the collateral case, is Mr. Clenney was listed by both the state and the defense, and the communications in writing by Mr. Clenney with the defendant's counsel are all discovery needed provided. So notwithstanding the fact that the state received some of those communications via a warrant to Ms. Deborah Clenney, those communications, all of them, are discovery to the state.
is that in your motion to compel?
No, Judge, the point is that some of this became sensitive investigative issues once it was discovered by the state in December. So some of the matters I just could not approach because frankly, I referred it to Miami Police because I'm not an arresting authority and I'm not an investigator, I'm just a prosecutor. So some of these matters I just could not disclose.
So in other words, what he's saying is that in December, this is when they realized that there was an issue with this laptop. There was some sort of unauthorized access to Obumseli's laptop by the Clenney family. And so he's saying that, there was information that we wanted to get on the Clenneys, but I couldn't actively do that myself because, now we had an extra investigation that was happening as of December, up until, the end of January when they actually were arrested. Um, so he's saying that now there's a new issue that's coming up, and I will tell you guys now at this point, a follow-up hearing has been calendared for February 16th for another motion to compel and another motion to show cause. Some of the issues in this hearing that are being brought up, like new issues that were not in their previous motion that they had filed, not in any of the reply papers, they're going to be talked about and basically decided on the 16th. So this is one of them. The communications between Kim Clenney and others are going to be some new things that they are going to want, and for new reasons now that they have this whole new criminal charge against the parents.
Or pursue, because then it would hinder that investigation. So, but it's just a basic obligation of the rules. There's no obligation for a defense attorney to invoke discovery. If they do, then they have to comply with it.
Right, so what is it that you believe that is outstanding, you are specifically asking for this time? I know that there were, it looks like the videos pertain to potential expert witnesses that I think at least one or two of whom have been listed. Yes, at some point the state is entitled to discovery regarding those expert witnesses if they've, drafted reports. They are entitled to retainer agreement, but what is it that you believe at this point specifically that you are requesting that is in your motion to compel?
Yes, Judge. The state is requesting the names and addresses of all witnesses that the defendant has, quote, uncovered, because that's the words used by counsel. I'm not making the throwaway. That were present for any of these recordings, a list of the individuals that were present for the recordings that were made and provided. Specifically, there's several set of videos, but the studio video, for lack of a better term, one where there were 5 different takes, and there was a secondary video that looked to be outside. I don't know if that was only the defense's expert or other persons there recording it. Those people are pertinent for the any discovery. The audio of the videos that were already provided.
So it sounds like so far there are some more videos that they're trying to get from the defense. One of them they've provided to them, but there was no audio, which he says it's clear from the visual that there are communications happening. So we are entitled to those. Absolutely, they are entitled to those. They're also entitled to other videos that may have been produced for the purposes of expert testimony or expert analysis as well. If they've been listed as witnesses, then yeah, and any kind of reports that any expert creates, they are going to be entitled to. So it sounds like there's more video, whether it's from things that happened, like during the relationship or during any of these conflicts that happened throughout the relationship up until the end, or perhaps there could be some sort of like reenactments videos that have been created, perhaps by experts to sort of analyze how, they might say, for example, that it is possible that Courtney Clenney could have thrown a knife at Obumseli from 3 feet away, and it could have hit his clavicle in a particular angle and landed the way that it did. Because that's the medical examiner that from the state says it's not possible. This is definitely a result of a close contact stabbing. So anyway, so there are a number of videos that it sounds like we are going to be getting that we have not yet seen.
That was involved in the editing of those recordings as well. Particularly some videos were in slow motion. I don't know if that was a subsequent edit or anything else. That's obviously pertinent discovery. And then
and some of these videos have also been I don't want to say tampered with or messed with, but they've been edited in various ways to change them, to slow them down, for example. So without more detail, we don't know if they are slowed down versions of things that happened or slowed down versions of recreations of things that happened.
Actually, in the last line of our reply, I put statements and reports of any of the witnesses by the defense that exist in their care, custody, and control. That, and the state would just piggyback, since they amended the discovery yesterday with some witnesses, whoever those witnesses are, if there are statements of those people.
I can't tell whether the witnesses that were listed yesterday were experts. I'm not sure who they were, but you guys can respond to this request.
Sure. First of all, Judge, under 3.220, the defense has no obligation to disclose witnesses unless we intend to call them. It's that simple. The witnesses that we listed recently, we intend to call.
The experts as well.
Well, the two experts that we listed, I think, a couple weeks ago. Yesterday, I amended with 4 civilian witnesses. I believe it's 4.
These are also.
Those are civilian witnesses, one of which, Arthur Cupp, we identified through body-worn camera that the state provided to us, so that person was readily available to them as well. He gave a statement to police, so his statements are contained therein. Any interviews that we've conducted of these witnesses, we will get those statements over to the state prior to them deposing them, so that they can be well prepared to do so. As far as the audio of any video, I was present for the filming of our reenactment. There was no audio taken. I will double check with the film crew. I don't see how a cameraman is going to be listed as a witness. I guess I can list him as a C witness that shouldn't be deposed. I mean, these are ministerial acts by these witnesses, but I will get a list of the film crew that was there and provide that to the state.
And then editing, any reports that are being generated by your experts. I don't know whether they've been generated yet, but.
No, there are no reports, Judge. And as far as the editing, that will be, I don't even know who did that, but I'm guessing it's the producer that we contracted with, which is Cold Power Filmworks.
That's going to be discoverable.
Sure, yeah, we'll list him.
And then anything that.
Yeah, so it sounds like they definitely filmed a number of reenactments, and they probably put quite a bit of money into it as well. I mean, if you have been following like the Alec Baldwin case, for example, you might remember how Helena Hutchins' estate, the family, they had put out like some videos that were reenactments of like what had happened or what they think had happened inside that the small church in New Mexico when the gun went off. They published those as part of their like PR statements to sort of like simulate like what had happened. They're able to do that, and we've seen that before in other trials as well. For example, the Gwyneth Paltrow ski crash trial, we saw some like digital reenactments essentially of like of the skiing and where people were at various points in time, and sort of, and they would put that in, would get that in with an expert who would be explaining the physics of like what was going on or what have you. So that's something that we will probably be seeing a bit of in this particular trial. And probably with an expert explaining like how this thing was possible or how this thing likely happened. Also, question. Oh, Debbie Faison Cook wants to know, is her attorney appointed or retained? Retained. This has not been an appointed attorney. This is someone that she at the time of her arrest was a multimillionaire. Her parents, I believe, also are like multimillionaires independently of her and her work. So this is a family that has quite a bit of money. So yeah.
Would be typically discoverable with your experts. You're going to have to turn over, which involves, their CV, the cases that they've been involved on, the retainer agreement, anything they're using to rely on when formulating their opinions.
Yeah, the two experts that we've listed to date, Judge, we have provided a CV for our medical examiner, and also every single case that he's testified for, we've provided that already. There are no reports, so there's nothing left to disclose on that particular expert. Our knife throwing expert didn't have a CV. I know he worked on it, but we did give the state a biography page that's on his website. That's the best we could do. So we can't provide something that doesn't exist. But as soon as it's all put together, we will do that in due time.
The
There it is. They are going to have a knife throwing expert. That's confirmed in the hearing.
retainers we will provide.
All right, so, and again, I'm just going back up to this portion that the state brought up first, which is the names and addresses of all witnesses that have been discovered. And I think that was taken from maybe some sort of media clip or from just your words. Are there new witnesses that are on the defendant's witness list, some of those witnesses? Is there anybody else that you intend to call that you have referenced, that you have not provided?
No, not at this time.
All right, then at this point, I don't know that there's anything else that I can compel. And it sounds like you guys are amenable to turning over everything that is acceptable.
The one thing I will mention is Mr. Quinnen did make reference to communications with Mr. Clenney, Kim Clenney.
Yeah, that wasn't in his motion to compel, that was just made reference to right now. I think that that's going to be a more touchy subject because of the nature of, what communications are privileged and what aren't. So I'm going to ask you to put that in a separate motion, and we're going to address that, especially given the fact that he's not charged, I think, separately. I think that's the safest thing to do that there.
Your Honor,
That's going to be a very, very interesting subject because there are some communications. I think they mentioned it earlier that there are some communications that are also between Kim Clenney and Frank Prieto, the lead attorney here, the lead defense attorney. And so the question as to whether or not those are privileged, they by default shouldn't be because he's not the client. Courtney Clenney is the client. But there are some other exceptions to that could eliminate the waiver of a privilege or of attorney work product immunity for particular communications. Also, Draco Amy, thank you so much for gifting 1 Legal Bites membership. So kind and generous of you. And Flash Fan 85, welcome back to Bite Club. Happy to have you back. All right, let's continue on.
just two matters before we move on from that. The 2 witnesses listed yesterday have to be determined addresses in Canada, and then we have international issues in terms of setting them in service. That we'll cross that bridge, but I'm just.
I mean, at some point in time, you're going to have to make them available for deposition. I'm sure that they know that. And yeah, you can't send them a subpoena at TBD.
Yes.
And also, just so the court knows, is that these were individuals that were also interviewed by the police on the 8th of the night of the incident. So the state is aware of them and has their recorded statements already.
But their addresses aren't listed in the warrant.
Correct. Judge, I can clarify that for the court. Our investigator attempted to speak with them again, and they had subsequently changed their phone numbers. But we do know that they reside in Canada, but at this point, I don't have their address. I don't have a contact number, but we will be obviously working on that. But again, the state has their statements that they make to the police, and I believe they're actually, I don't know if they're actually listed by the state already. They should have been, but so they're state witnesses as well.
So, okay, so these are people that had talked to the police. They were there, I guess, the night that it happened. We're living in Miami now. They're living in Canada. That's very interesting. I wonder what brought them to Canada. What made them leave Miami? I wouldn't be terribly surprised if participation in a trial like this is like something that would make them want to like get a little bit of distance on some of that stuff. But I mean, I also wouldn't be surprised if it was completely unrelated to that.
I'm sorry, because we didn't get to address the second matter. The second matter is when witnesses are listed by the defense, there's no category application to the defense. Only category applications apply to the state. The state has an absolute right to depose all witnesses.
That's fine.
And that's where our issue becomes is they might have been listed by us because we have an obligation to list all persons we know to have information. Once they list them, it triggers our right to depose them. And that is the equation here. And I do want to highlight one more issue before we move on from compelling, is that it's always on the eve of a motion before this court and a hearing in this court when we receive reciprocal discovery. That is a problem because the rule triggers 15 days. I absolutely appreciate that the 15-day period is when the defense decides that they're going to do that at trial. But that exception, that definition would swallow the entire rule if we decided yesterday, we decided this morning. And so I just want to make sure that everyone's aware about that, is you can't just have,
I'm gonna have to take them at their good faith, statement that they are filing this in a timely way, as soon as, within 15 days of them looking together, that they're going to list the excise potential witnesses at trial. Okay, all right. And hopefully not leave. Okay, so that I think takes care of our motion to compel. It sounds like you guys everybody's in agreement as to what needs to be turned over. As to Mr. Clenney's statements, that's gonna be separate.
so can I ask for a formal ruling that it's granted?
Yeah, it's granted. And I don't know that there was, let's see if there was is there a proposed order attached to it? If not.
No, Judge, because I figured it would be more, I'm working with what's said publicly, so.
Judge, we'll draft one, we'll get it
Okay, draft it to me. I have notes here that if anybody has any questions, we can go back to the record and go over what was granted. Okay? All right, so let's go to the second motion.
This is going to get even more spicy. Also, Flash Fan 85, member for 6 months. Thanks so much for being a member for 6 months. Hi, Lita, my fave law tuber. Love and support you. Thanks for all you do. Thank you. Thank you so much.
All right, so let's go to the second motion, for which I received another response to yesterday. Or I guess it states reply and response. In support.
Okay, and also just to sort of wrap up that first portion. So that was the discovery motion. They were the state had moved to compel the handing over of evidence by the defense. Defense said, "Yep, we're totally willing. We're willing to give you, the names and addresses of these other witnesses that we have listed and put TBD on their contact information, and we're also willing to hand over, this other video footage and whatnot, and also if there is a version of it that has audio, we'll hand it over to you, and then they're also going to give some information of the people that were involved in making those reenactment videos from whatever it was that they made, probably for the purposes of expert testimony." So I don't know exactly how many of those people that were involved in that they're going to do, like the editor, maybe the camera guy, I don't know, but they're going to give a number of people over for the state to talk to them. So anyhow,
Its own petition.
so and this is now the gag order question, because this is getting into some of the statements that the defense has made to the public, and whether or not that starts to run afoul of the rules of professional responsibility. And this also, by the way, includes statements made by Kim and Deborah Clenney to TMZ for a documentary that's coming out. I didn't even know about this documentary until I watched this hearing, and I was like, there's a documentary coming out that they sat down and talked to TMZ. Yeah, that happened before they were arrested. So you'll hear a little bit about that.
So let's go to the original petition, and we will start addressing the issues here. Really quickly before we go on to that, we're not addressing, I know that the last time that we were up, we had the motion to suppress, and the defense had withdrawn the motion that they had filed. Was there ever an amended motion that was filed on that? We're not working with it.
Not as of yet, Judge. We're
Okay,
working on it.
So then let's go back to the workshop, please. All right, state. I have read the response, the reply in support of that you wrote yesterday. I've obviously read the ones that have been previously filed. I know that a lot has happened within the time between the original filing of the the petition for order show cause, and today. So let's just get started.
We're gonna get the full
Yes,
history
Your
on
Honor.
this.
The state filed the petition to show cause on November 3rd. We emailed it to counsel. We did not calendar the matter as a matter of professional courtesy to the respondent. There's, in trial, of course, the trial where previously, there's the expression about ringing the bell. And once the bell is wrong, it can't be unwrong. The state has, on purpose, because of the attention created by this case, specifically by the respondent and his client, not sought to limit public speech by anyone. When this case came in, counsel filed a motion for injunction and protective order. And the premise of that order was essentially so that the court would micromanage discovery and would supersede Chapter 119. That's not tenable.
Chapter 119 is Florida's sunshine law, essentially, that allows like free information to the media about these court cases. This is transparency, full transparency for all of these hearings and these trials and whatnot in Florida. This is why if there is a big case that happens in Florida, it's almost a guarantee that there will be cameras in the courtroom, unlike places like New York and California and other places where they are much more likely to be restrictive on that. So anytime they reference Chapter 119, this is the sunshine law that they're referencing, which is a very strong law in Florida. So what he's saying is the defense at the very beginning of this case asked to have like a protective order a protective order over all of the information in this case, basically so that the judge would have to look over every piece of evidence that they that basically came out at trial or in the pre-litigation process before allowing the media to see it. This would require so much more onerous work on the part of the court because there's bound to be so much evidence that comes in any kind of a trial. But just based on what has been leaked so far in this case, I would venture that there's a lot more of it even that we still haven't seen. So this is what the prosecution is saying that the defense initially asked for at the very beginning was to try to clamp down on the information. I don't know if you guys remember that, but that's what they tried to do at the very beginning. They lost, obviously, because we've got cameras in the courtroom for the hearing. We've gotten a ton of information from the evidence that's been shared in this case. So okay, let's continue on.
Judge Escanio at the time rightfully denied that motion. The premise of it and counsel's issue was that the elected state attorney at a press conference, she announced the charges. She stated the arrest warrant facts and provided one of the examples of the arrest warrant. As the court would know, the state does not telegraph its case on an arrest warrant that requires mere probable cause. And we did not. That was on purpose. The state is thrust into a position, particularly by the defendant's counsel, who maintain this case's interest in public, to inform the public that there was actions by the state. And I juxtapose that against the last 48 hours where the state has not made any public comment and has not made any public comment since. The defendant and the responders have chosen to telegraph their case in public. That is their prerogative and frankly formed a lot of the basis for the state's motion to compel. Absent statements made by the counsels, the state would not have a basis to move to compel discovery because we wouldn't have known.
Oh boy.
So
in other words, he said that the state attorney had one press release where they announced the charges and that was it. That's the only statement that they've made to the public. And, they don't want to be messing with the jury pool or anything. That's at least what he's saying, right? I mean, there can definitely be a lot of like, well, we have clean hands here, Your Honor. Like, we just want them to be held to the same sort of standard, but really it's like knowing that there are certain difficulties that are placed on the defense that aren't placed on the prosecution through various mechanisms. But anyway, so what he's saying is, we haven't made any statements to the public. However, the defense, on the other hand, has chosen to telegraph a ton of on this case, and actually, it's benefited us quite a bit because things that they've said have led to our realization as to certain pieces of information that's out there, different avenues for us to go down in order to get more information. And so, basically, like, they've really helped us out by making these public statements in the past.
That effect, the state has deliberately sought not to raise this issue. One, as a matter of professional courtesy. Secondarily, because there is a great public attention and interest in this case. And thirdly, and I say this with complete candor, it was benefiting the state. A defendant telegraphing their case benefits our strategy and benefits the state's litigation. So we sought no interest in limiting the defense counsel from telegraphing their case. I think a common expression used here is the defendant had a right to remain silent, but was unable to. And we were perfectly okay with that. The defendant's attorney walked a very fine line several times, as we outlined. There was this court's hearing on the Arthur hearing, where he made inappropriate remarks, the state objected, of course, sustained. Then several interviews, remarks the state would not have, suggested making a finding. The respondent walked up to the line when he called the victim, who's deceased, is unable to defend himself, an animal. And there's a particular history that comes with humanizing people, and the big elephant in the room is the racial disparity. That cannot be ignored, but the state nonetheless restrained itself. That crossed the line, the respondent crossed the line when he gratuitously, and I don't know if the court has reviewed the video, but it's been available for the court, not a response to the question, not prompted for no other reason, just volunteered that the victim was sexually battered by a family member.
Yikes.
That's not appropriate. That achieves no goal. It is not asserting the innocence of his client. It is not saying the evidence will show that his client is not guilty. It is not saying when the case will be heard next. It's not discussing what preliminary or procedural matters might come up. That was, for lack of a better term, a cheap shot.
So all of these, the things that he just listed through, that this is not not saying, when the next hearing would be. This is not, saying that, the evidence will show that my client is innocent. This is not, talking about a procedural thing. What he's referring to is specific things that an attorney can say to the public under the rules of professional responsibility, which are very, very, very limited. So rule 3.6, let me just show you guys real quick. I'm going to stop the screen here and I'm going to share this tab. Okay. So this one, 3.6 publicity. This is basically like these are these are basically the outlined things that a lawyer can state to the public, which means that there's a lot that they can't say to the public. So, like that an investigation of a matter is in progress, is scheduling or result in any step in litigation, like you're really, really, really limited to what you can say. However, in a criminal case, in addition to subparagraphs 1 through 6, they can also say the identity, residence, occupation, and family status of the accused, the fact, time, and place of arrest, et cetera, et cetera. However, down here is where we get into a little bit of an exception, and this is where the defense is really going to make a lot of argument. Notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made to this pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So in other words, if you've got a defense attorney who is concerned about tons of negative publicity that their client is getting because of, they're a criminal defendant in a murder case, and there's stuff that's coming out that is causing a lot of really bad publicity, they are allowed to go out and make a statement to the public to sort of help combat some undue prejudicial effect of that publicity. However, they can't do more than what is necessary in order to combat that. And so the statements that the prosecutor just mentioned, and let me go back to the other screen again. The statement that he's referring to as a cheap shot, statements about Obumseli possibly having been abused by a family member at some point in his life. Obviously, we don't have the context of how, like, what conversation happened, what sort of interview that the defense attorneys were giving when they made that statement. But it's hard to imagine how that fits within the narrow scope of what is allowed, even in circumstances where the defense attorney is trying to mitigate bad publicity that is out there because of other stuff that they didn't create. All right, let's continue.
And that crossed the line. The state is then left with the remedies, or the following options. Do nothing and embolden the behavior that has been progressing and escalating. File a petition to show cause, not calendar it. Contact counsel and say, please stop. File a petition to show cause and calendar it, or move for a protective order and a restraining order against counsels and the litigants from making public comment.
So in other words, at the time, after the defense attorneys made this statement about Obumseli potentially having been abused, this prosecutor, excuse me, basically said that there are like four options here. We do nothing, allow it to continue. We can file a motion for an order to show cause. Don't calendar it. In other words, don't ask for an actual hearing on it, but just basically talk to the defense attorneys and say, hey, if you guys continue, we're going to move forward with this, but we don't have to move forward with this if you guys are willing to chill your comments to the press. Or three, they can go ahead and calendar, or four, try to go for an overall protective order, a gag order, essentially on the defendants. Now, there are going to be some issues that with a potential gag order that the defense is going to bring up, they have some valid points that they're going to be bringing up.
The state took its least restrictive means. And again, out of professional courtesy, filed the petition because it needs to be a matter of record, sent it to counsel, emailed counsel, and we are not calendaring the matter. We hope the conduct in the petition ceases. 3 months later, the respondent chose to reply and bring up the matter with the court. So the state handed.
So in other words, this was 3 months ago that the prosecution decided to file this motion for an order to show cause. And then the defense didn't respond until recently, when they're the ones that asked to put it on the calendar to talk to the judge about, which is interesting. It's interesting because the restriction seems like it would be more on the defense rather than the prosecution. So why would the defense want to put it on the calendar to talk to the judge about it? It's interesting, to say the least. Also, Shireen, member for 16 months. Thank you so much for being a member for 16 months. Also, one of our wonderful mods on the channel. Good to see you all. Thanks for, I think, doing this is what you meant to say. Hit like. Definitely hit the like button if you guys are enjoying this coverage. Really, really appreciate you guys doing that, because it really does help those YouTube algorithm gods to push this out.
He has not sought a remedy on this matter frankly, as far as the state was concerned, because there was also no reply to the state's communication, we thought that it was water under the bridge. And we're here litigating this matter because the respondent chose to. To skip ahead regarding our reply, since the state's petition to show cause, and the state has not amended its petition to show cause or filed a subsequent petition to show cause, the respondent has arguably engaged in further conduct that is further escalating and raising the temperature that requires this court's attention.
Okay, so in other words, he's saying even after that comment about Obumseli's past, now there's been some other stuff that they've done that is continuing to raise the temperature that is outside of what they are arguably allowed to do as part of their representation in talking to the media. Okay, this is a claim by the prosecution, but we're definitely going to hear from the defense as to how they see all of this, and obviously it's going to be a very, very different perspective.
Again, we discovered this knife throwing not from court pleadings, this knife throwing expert, but from counsels on TV. We discovered that there would be a reenactment video, not from counsels, and there was email communications by the state with counsels during that time regarding discovery, but from the respondent's co-counsel the day before Thanksgiving going on TV. That's not a way to litigate this case. We then spent, and I outlined in the motion to compel, almost 30 days berating the defense via email to provide us discovery because we did not want to delay the proceedings. We want to.
I don't think he meant to say berating, because berating is like when you're like talking down to someone, you're like, maybe he meant like browbeat. I don't know. Maybe not browbeating. Like they were really trying to press them for that information. But berating, I don't think is the word that he meant to use.
Review whatever the materials are, decide our strategy, conduct our discovery, and litigate the case. It's been 17 months roughly since the defendant's been arrested. April 3rd, 2024 will be 2 years since Christian was killed. And it feels as this case is moving at a snail's pace.
Amen to that.
So to put it bluntly, we want to get down to brass tacks and litigating these collateral matters.
True crime with Amanda Warner. Badgering. That's the word he was looking for. That's the word. That's the word. Thank you. Yeah, berate is to tell off, says Shireen in my English head. Yes. Yeah.
Are not in the state's interest. And it's especially the state has not sought to address this matter. So the respondent wishing to take up this court's time with that matter rather than getting to the discovery. And frankly, the statements that have been made in the last 48 hours are just increasing that temperature. And if counsel wishes to litigate and get an order from this court, the state welcomes it. We will comply perfectly with an order if this court were to craft one with the Toledo. We provided the court a draft of that order that was affirmed on appeal. The state has no public statements to make about this case. We want to try it. We want to try the defendant and her co-defendants as expeditiously as possible.
Which, I mean, it is kind of funny that he's like, the state has no public statements about this case, but he kind of is doing that now because obviously he knows that the cameras are in the courtroom. Obviously, all sides know, everybody knows that the media is watching. Everybody is watching this hearing. Everybody is very interested in this hearing. You know, Court TV's in there, Law and Crime's in there, the Miami Herald is in there. And so it is, I mean, yes, it is technically correct. They have not made any PR statements, right? So technically it's correct, but it is kind of silly to hear him say with a straight face, like, Your Honor, we have no public statements. We have no statements to the public, you know, for in this case. We haven't made any, even though it's like you kind of do by virtue of this hearing. Now, of course, you are technically talking to the judge, but anyway, it's just it is just a little bit juicy to me.
In your response, you had also mentioned, and I also happen to see the fact that, and I don't know whether you want to address it, but like, if you're going to free to go ahead and do it now, the fact that there is some sort of docuseries or TV show in the making prior to the trial in this case, where
TMZ,
the
here we
officers
go.
and the witnesses are allegedly, interviews are being sought from everybody. I had also seen it online.
Yes.
And was very surprised to see that.
I can address that. So the state has not ever been approached regarding from TMZ regarding our comments and participation in this docuseries. We learned about it almost contemporaneously with one another. We served a subpoena on the defendant's management company for behind the scenes information, contract, et cetera, premised off of the respondent's statement that she was allegedly human trafficked. So we expect that might come up in trial, so we might have to rebut that.
That's also something that was new to me when out of this hearing, is that Courtney Clenney is claiming human trafficking, and it sounds like she's claiming that she was human trafficked by Obumseli, which is kind of a wild accusation. So he says that that's why they went to Courtney Clenney's management company, is to talk to them about, ask them questions related to that claim. But that's, like I said, that was something that was completely new to me out of this, is that now there's also going to be not just allegations of like DV and, self-defense, but also human trafficking on top of that. This is going to be very, 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 very interesting trial, I think.
The counsel for that company informed us that they were approached by TMZ regarding a docuseries that they wanted to interview his client. At roughly the same time, and the court has the emails in our exhibits, the city of Miami's public information officer received a request from TMZ to interview the lead detective by a person named Brian Andrews. He's a former local newscaster and the president of a PR company. We didn't want to blow up anyone's Christmas, and New Year's. So Mr. Abeloff emailed the respondent and his counsels requesting this, whether they were participating in this because it's inappropriate. And 30 hours or so later, we get a response, essentially neither accepting or denying anything. And about 10 days later, we find out from Lexington Capital that on that date, the respondent sat with the defendant's co-defendants for interviews. And there's actually a few matters that came to my attention after the state's reply yesterday. TMZ aired parts of those interviews already as a apparent teaser.
Let's take a look at it, shall we? I have that queued up as well. This is, let me see here. 1 second. Okay, hang on. 1 second. No, I've got to refresh this real quick. Okay. All right. Okay, let me take this off the screen when my computer decides to start participating. Okay. Whoa, what am I doing here? Okay. Stop screen. Oh, okay. Well, whatever. Anyway, I meant to do that. Okay. So this is an article that came out on the 31st. Courtney Clenney's parents knew they were being monitored before computer charges. So this is the trailer here that they show, at least in this article. Maybe there are more trailers that they actually show here. Okay, hopefully the sound plays.
I believe it's the other side, which I think is all one group and working in concert with each other. They will do and say anything to win this case.
Every word we say to each other is being recorded, and the prosecution plays dirty, and I think they would use anything we say to each other. I mean, they tried to act like I was manipulating her by texting her to say, even though it was self-defense. So I think they would use anything against her that they possibly could.
So yeah, that's at least a portion of it. Is there more? I think that's it. Okay. Um, so yeah, that's the little bit here. And when does it come out? It's like on the 12th or something, I think. It's like really soon. Let me see. Maybe it's at the bottom. Okay. Oh, and this is their mugshot, of course. Okay, February 12th. Yeah, it airs in 2 weeks on Fox at 9/8 Central. So February 12th is when this killer OnlyFans model deadly love story comes out. Crazy, crazy, crazy. Okay, so anyway, so that's um presents a number of issues. Actually, the fact that they said that on camera, the fact that they know that they have reason to believe that they are that the prosecution is like tapping their phones and listening in and reading their text messages or what have you, that could actually come to bite the defense in the ass in terms of whether or not these communications should be given over to the state, because it sounds like they don't have a reasonable belief that their communications are actually private. So it very interesting, and the fact that they decided to sit down for an interview like this, going into it, especially when the mom is so closely implicated in it, because there were those two phone calls that Courtney Clenney had with her mom, like in the midst of this whole incident, before stabbing, after stabbing. I don't remember exactly because it's been a minute since I looked at the arrest warrant, but mom is so closely involved in this, it sounds like, that it just does not seem smart at all for them to have sat down for an interview like that before the trial. All right, let's get back to the hearing itself. But I wanted to show that little bit of like what it is that they mentioned the teaser, and I just wanted to show you guys what that looked like.
So, the damage has been done. There's nothing for the state or the state or the court could have done, but it further reflects and impacts the perspectives and nature of this litigation. And the state wanted to take another step on this too, because again, it was brought to my attention yesterday, in part because the reply was being drafted and matters have been developing. TMZ, I believe, was the first to report the arrest of Mr. and Mrs. Clenney. And that reporting stated that they were arrested for tampering with evidence. Clearly, the arrest warrant doesn't state that. Clearly, the facts in the arrest warrant don't state that. Clearly, the state's information that was filed and sealed at the time didn't state that. That was not a correct reporting. And the state has concerns about the communication based on an inference of whatever was told to the Clenneys on scene, because they weren't told that they're charged because they refused to speak to the officers. So given the intimate personal relationship the respondent's been having with TMZ regarding this docuseries, the state has obvious concerns that there's essentially going to be something televised, and particularly the state's concern, because it was alleged by the emails, is that this is being telegraphed from a particular perspective. And the state does not get to air an infomercial of the defendant's guilt before trial. So the defendant should not be either. And that's inappropriate conduct that the court should be alert to.
Okay, so a number of things that he just said are really interesting here. That so TMZ got it wrong as to what the actual charges were. They were close, but they got it wrong. It's interesting because they were the first to report it. They also reported seemingly what the Clenneys would have known about what they were being charged with at the time, because they refused to talk to the police. They had some sort of an idea of what it was. So maybe it sounds like the Clenneys have a sort of backdoor relationship with TMZ about the case, that they've been like trying to feed information to TMZ perhaps about the case. And so most likely was that this arrest happened. Police showed up at their door. They refused to talk to the police, and then they turned and told TMZ about the arrest, and so therefore, um, told them what they knew, and TMZ rushed to publish. I don't know. It's interesting. It's very interesting because it sounds like there is sort of perhaps this sort of backdoor relationship that the Clenneys have tried to develop with TMZ. So interesting to see what happens moving forward. Now, of course, also prosecution made a really interesting point there too about the fact that TMZ did not once reach out to the state to try to talk to them about this so-called unbiased documentary. So this has to have come through a particular vantage point. I don't know. Maybe not. I mean, TMZ is going to do what TMZ does, and TMZ is always going to act within their own interests. Whether those align with the Clenney parents or whether those align with the state or whether those align in a more unbiased fashion, no idea. No idea. But it definitely brings up a number of questions for sure.
Judge, I can only say that
Judge, I object to Mr. Hanfield addressing the court for this particular motion. He's a victim advocate under Marcy's law. They have no standing to address the court for this particular motion.
Right, so, yeah, Mr. Hanfield, right now I want to hear from the defense. You were the one who calendared this, to bring it to, I guess, my attention. It hadn't been brought to my attention before. But given everything that has been going on, particularly the possibility of a docuseries prior to trial, I think that we should be addressing it. So, for whatever reason you brought it to my attention, the state hadn't brought it to my attention, it hadn't been documented, you documented it, so let's discuss it. What is it that you believe is appropriate about what you have been doing with the media, and why is it that you believe that you should be allowed to continue to do that?
Sure.
Oh, that's an interesting way for her to ask it. So tell us about why you think that what you've been doing is appropriate and why you think you should be able to continue to do that. Like that's a tough question. So by the way, you guys may have missed it because of the timing of when I paused it, but there is a third attorney that's in the room. That's the one that's representing the Obumseli estate. And so he came forward. He wanted to address the court, but the judge did not allow that because that's a separate matter, the civil case. And so he was not able to speak. And I don't think that he's going to get an opportunity to speak in this hearing, if I remember correctly. But it's interesting. He's there. He's definitely there. And the civil case is kind of going to come up in this whole gag order subject as well. Also, Debbie Faison Cook, Alita, I'm sorry, but I'm confused. Why are her parents included in this hearing? Why aren't they separate cases? I don't understand. So they are separate cases. They have their own case numbers that are brand new, which they actually mentioned in the beginning of the hearing. But they are related because of the fact that the statements that they made to the TMZ for the purposes of the docuseries were related to the Courtney Clenney case. That's why people that's why they're talking about the parents so much with relation to the potential gag order, is because of, in particular, they don't know what's going to have happened in terms of their statements to the press for the docuseries. Now there's also like that their charges are also related to the case also because they involve the pre-litigation phase, right? The potential tampering of evidence. There's no charge for that yet, but there is a potential for tampering evidence charges. So that's why they're talking about the parents here, but the parents are not actually at the hearing. Of course, they don't have their own representation. So anything that is going to be decided that would impact the legal rights of the parents would not be able to happen at this hearing because of the fact that they are not there. They're not there themselves and they don't have legal representation there for them. A Flash Fan 85. So why have him there if he can't talk? Wouldn't that be kind of pointless? Well, I think he chose to be there. I think he knew that this hearing was calendared and he chose to be there just in the off chance that he would be able to address the court. No one invited him. No one asked him to be there. So that would be why.
Judge, and first of all, I'd like to say that I'm not sure a petition for order to show cause is the proper avenue. I think a motion seeking some type of protective order is more appropriate, but procedurally, the court can address it however it would like.
It's the first time that it's ever been in front of me on any sort of petition on any of my cases to address this issue. So I'm not sure what the appropriate avenue is, but we're here to see whether or not there needs to be a full response or anything.
Correct. And Judge, I brought this to the court's attention by countering it because this was already filed. It was filed by the state. And what happens once it's filed, based upon the media attention that this case is receiving, the media, either through public records requests or now finally the clerk has finally got us like electronic access to the documents that are filed. It's open to the public. And in that particular petition, quite honestly, there's comments in there that besmirched my reputation. And I'm not going to sit by idly while I'm attacked by the state. And with regards to inappropriate comments that I made at the Arthur hearing to the lead detective, I'm going to rely on my written response. I'm not going to dignify it with a reply, verbally.
And I don't think that that's the bigger issue here at this point. So
Sure. And the state saying that they had to barrage us with emails for 30 days. If Your Honor recalls, that's the time my father passed, and I'm sorry I didn't get it to them faster. But we're working this case. We've taken lots of depositions, but this particular petition filed by the state, I believe, needs to be addressed because we are constantly, from the defense side, being barraged by them from day one. And, the state saying they can't unring the bell. Well, you can't put the toothpaste back in the tube either. And that is why.
So many metaphors. Can't unring the bell. You can't put the toothpaste back in the tube. They mean the same thing. They mean the same thing, but it sounds like he's almost like, well, yeah, well, I can metaphor too. Shireen, yeah, he is spicy with the judge. He sounds very angry. And maybe this is just his litigating style. Like he's just the kind of guy. That's not my personal style. I don't do well with litigating while angry. For me, it's a lot better to just stay calm. But I have worked with is maybe not the right word, but I have worked opposing counsel who has been like this, that they seem to be fueled by anger. In all aspects of the litigation. So it's like whether it's a hearing or whether it's just an email response, it's like just anger. I don't know if this is, I don't have enough data points on Frank Prieto to know if that's always his style or if he's just particularly angry here in this hearing. Oh my gosh, Debbie, that's funny. Or as EDB says, he can't put the shit back in the horse. Yes, also a valid metaphor.
Onset of this case, I sought a protective order to limit the discovery being released under Chapter 119 because I knew this was going to happen. The state aligned themselves with the Miami Herald and fought me on that. All I wanted to have, and Your Honor was not sitting in this court at the time, but all I was seeking was an ability for the court to review discovery prior to it being released under Chapter 119. Not a
and also, let him finish.
complete gag order at all, because the writing was on the wall. My office probably received 15 calls as soon as the arrest was made. I wanted to limit this, and now the state can't have it both ways. It's the pot calling the kettle. They know.
Okay, let me get this really quick. Where? Yeah, Olivia. I missed this comment this time around, but I remember him saying it before. It's horrible that his father passed, but is there not other lawyers that could have helped completely? Yes, 100%. That's the thing. That's the thing is that, life happens for litigators. Life absolutely happens for litigators. You have a death in the family. You have a big, wedding that comes up. You have a graduation. You have, these things that come up, and you've got all these things to juggle and you still have a life to live. However, when those things do come up, this is why you ideally work with a team. Even if you are a solo attorney working by yourself, oftentimes you have someone that you can pull in case you need them into a particular case, just because you're overloaded with work or something like that. That stuff happens. But here he has co-counsel, he has a firm, he has other people that can man the ship while he is dealing with something. Now, of course, sometimes being able to administer, handing over workloads and things like that could be impacted by emotions, of course, but these cases still have to move forward, even with life happening. So, completely agree. It's, horrible that his father passed. Absolutely. Like, to say that it sucks, like, is like, almost like a cheap comment, right? But the cases can't languish because of that. Cat Love Dreaming Peach just became a new YouTube member. Welcome back to Bike Club. So happy to have you here. And thank you so much for supporting the channel. Really appreciate it. All right, let's continue with this.
Under Chapter 119, when they fought the initial disclosure of discovery, that this was going to be a subject of great media attention, and they were happy to list all the items in discovery in detail, and then began the onslaught of Chapter 119 requests made upon the state to get all the video. To take it back, when Ms. Clenney was arrested,
Onslaught from defense or onslaught from media?
Media. Judge, a very carefully crafted press conference was done. Ms. Wendell's been in office, I think, over 30 years. She was my boss. She was, I think, your boss at some point. They're very sophisticated.
So also interesting point right here that he just mentioned is he used to work for the state attorney, as did the judge. So these are all former prosecutors here, it seems like, other than co-counsel. I think she worked for like the public defender's office and the federal defender's office, things like that. So very, very interesting to see that he has some history, some work history working for the prosecutors. So, him complaining about, this is a very well coordinated, press release or press conference about this. Okay, sure. But they're allowed to do that. They're allowed to be smart about how they make statements to the public.
State attorney's agency, I think the second or third largest in the country. They have a public information officer. They knew when that discovery was released that they were going to receive tons of requests for the videos, the audios, which are subject to suppression, but that's a motion for another day. But they knew it was going to be released, and they know that every time a media agency makes a Chapter 119, they're going to throw their hands up and say, well, we have to comply with the Sunshine State laws under Chapter 119. We're not giving it to the media. But they knew that from the beginning that would happen, and now they're hiding behind that to say it's the defense that is putting all these things out there. They let the toothpick.
Well, they're not complaining about information being out there. They're complaining about the particular tenor and substance of some of the statements that the defense is making. But it is a reality, though. I don't think that that's something that someone can be like, Pontius Pilating their hands clean, right? That's not what's happening here on the prosecution. From what I can see, this is a very real law that they have to comply with. In terms of like the information that gets put out there, if they know that that's going to happen, then that's just the rules of the game. Right? I mean, the defense knows that that's going to happen too. And this is something that's also very, very interesting to me, is that watching this hearing, one of the things that I thought about afterwards is the fact that we haven't seen any sort of evidence leak that benefits the defense. And so it seems like, I have a feeling that the defense here is just, I mean, I'm speculating here. Keep that in mind. But if I'm to speculate, I think the defense is just really frustrated with the fact that they probably don't have the same kind of video and audio evidence that really, really benefits the defense, that they can just throw at the media and say, here, publish this. This is, like the state is not really being totally no, kitty cat. Is not being, totally forthright as to like the actual facts of this case. The fact that they don't have the fact that they haven't done that means that there probably isn't any evidence that benefits the defense. Maybe not. We'll find out at trial, but that kind of gives me that sense.
From telegraphing.
Oh my gosh, no. Kitty cat. She messed it up. Oh God. Okay, let's see here. Okay, defense's reason for no gag order. I'm sorry, guys. I've got to find our spot again because the cat. Blame the cat.
But they knew it was going to be released, and they know that every time
Good.
a media agency makes a Chapter 119,
Right
they're
over there.
going to throw their hands up and say, well, we have to comply with the Sunshine State laws.
They do
Under
that.
Chapter 119, we're not giving it to the media. But they knew that from the beginning that would happen, and now they're hiding behind that to say it's the defense that is putting all these things out there. They let the toothpaste out of the tube, and we're trying to put the cap on it. Why? For example, the video released at the press conference of Ms. Rundle standing there going like this, we take issue with that. We don't think the facts support that. The elevator video was released because why? It's great for the state. The media is going to love it. But they don't supply it with context, which is the danger that the state was facing by listing all the discovery and media outlets picking pieces of, oh, send me this video, send me that statement, send me this interview. Nobody wants to request the body-worn camera of the defense witness, Arthur Cupp, saying that she saw Obumseli beating Courtney. Nobody advertises that.
But there was body cam footage of, and I think it was Arthur Cupp. If it wasn't him, it was somebody else saying that he saw Obumseli like taking a swing at Courtney Clenney. That's the one bit of evidence that we have seen leaked that does benefit the defense, but it's not video footage of the event itself. It's video of someone saying that they saw something. So there's a bit of a hearsay issue with it in terms of getting that admitted. But I mean, that has been put out there and people, we saw it. We saw that. I remember talking about it.
No media outlets are covering that for the defense. The state's not putting that out there either. As an obligation to defend my client, the rules allow for me to give pushback, to characterize the evidence, to make sure that my client gets a just and fair trial. We're not.
So he is correct that the rules. Remember, I went through Rule 3.6 on trial publicity earlier, where it says that if there is negative publicity that comes out related to a case, the attorney for the criminal defendant in that case is able to make a statement to the public to combat substantive or substantial prejudice against them due to that publicity. But remember, they're supposed to keep it tailored to what is necessary to combat that prejudicial effect. They can't do more than that. It doesn't give them free license to go and say anything and everything.
Trying to impede justice. We're trying to make sure justice is done by showing when the media contacts us, hey, do you have a comment about the new video? It's not new. It's just they found it because the state released it. Or the Haggard law firm with Mr. Hanfield and counsel for the estate of Obumseli released another video. And then the onslaught begins. Mr. Prado, Ms. Puglisi, do you have that comment?
So that one thing that is interesting here for the defense's perspective is the fact that there's information that is being provided kind of publicly through the prosecutors, and the media sort of tracking what the prosecution is listing in terms of their evidence so that they can make a public information records request. And then there's the family, there's the estate of Obumseli that is also putting information out there. I mean, the most recent video of Courtney Clenney attacking Christian Obumseli in like Aspen, Colorado or something, that was released by the estate. So that wasn't the prosecution. That was the civil case that they were the ones that they are still advocating for Christian through like the court of public opinion even. So yeah, it's very, very, very interesting that they do, looking at it from their perspective, they are having to sort of fight this PR battle on multiple fronts. And so it sounds like they're very frustrated by it. Let me get there was a question here earlier. I thought I didn't track it. Or I didn't save it. So give me 1 second, guys. Sorry. Oh, so questions about whether this is going to be a fair trial. Well, that's the concern. That's the concern both with evidence getting released to the public, but also with statements being made to the press. So we want to make sure that the jury pool is not tainted by all of this information getting made to the public. Now, that's why the voir dire process is going to be so important, and it always is in any of these high profile cases, right? Because so much information has been put out there to the public that that a potential juror could have seen and could impact the way that they see the case. Now, there have been recent cases. I'm trying to think of which case specifically, but there definitely was one juror. It was in the in the Jonathan Majors case. There was one potential juror who got dismissed from the case because he said that he had seen some of the footage and determined that he couldn't be a fair and impartial juror, and that he had basically already made up his mind, couldn't be convinced one way or another from that position. And so sometimes you'll have that happen. You'll have a juror come up and say, yeah, I've seen this stuff. I've seen the evidence that's out there, and there's no way in hell that she's not guilty of this. As an example, or no way in hell that she is guilty, you could say, which more likely it seems like the evidence is skewed to the other side based on what's been released to the public. So but there also is a good chance that they find jurors who haven't seen anything on this. Maybe they're not particularly interested in true crime kind of matters. So yeah. Alrighty, let's continue on.
Comment about this new video. And in order to protect my client's right to a fair trial, I am ethically obligated to push back against the narrative that the state began to spin in August of 2022 when they had the press conference. Then again, when they fought the defense on a protective order, saying, no, we want all the discovery out there. Now they're complaining about the discovery that they released.
They're not complaining about the discovery that's been released. They're complaining about the statements that are being made. But the ethical responsibility, the ethical obligation that he's talking about is the ethical, the professional responsibility, the duty to zealously advocate on behalf of your client. So I will say, the defense is kind of in a little bit of a tricky position with a situation like this, because of the fact that they are required to zealously advocate on behalf of their client, and at the same time, they're not allowed to make certain statements to the public. But at the same time, they also are allowed to make certain statements to the public in order to combat prejudice. And in a similar vein, they're kind of required to do so because of zealous advocacy. So.
Messages that unfortunately show Mr. Obumseli was a victim of a sexual battery are in the text messages they made public. This is evidence that was provided to us, it was provided to the media. And now they're complaining.
But if the media didn't choose to publish those, then why bring them up? That's I think an issue, a little bit of a stain on the defense team for bringing those messages up that talk about Obumseli having been abused. If the media knew that that existed, maybe they even saw that that existed and they chose not to publish that, like it does speak a little bit to a sense of desperation on behalf of the defense for them to be like, "Oh, well, let me tell you about this on live air."
That it's being released and that I have to comment because things are being taken out of context. All the media coverage to date has been vilifying my client under narratives that we have an opinion of the evidence that takes a different take, that is supported by the evidence that the state produced to us. And we have an obligation to make sure that our client gets a fair trial.
Judge, if I may just add something. It appears from what Mr. Clinton said that they're not trying to prevent us from speaking to the media. I think that's what I heard him say. We obviously have a First Amendment obligation, just like the media has a First Amendment right to report. We are not trying to waste time in this case. Our client is in custody for almost 2 years. We want her to get to trial as soon as possible, but it makes it very difficult. This is not your normal case. With media attention, it unfortunately brings us having to respond to things. And one thing that I think is a perfect example of that, Mr. Quinnen mentioned that recently, within the last 48 hours, there's been news media coverage about the Clenneys being arrested. And one of the things talked about tampering with evidence. And he himself just now said on the record, which I'm very happy for, about the fact that this is not a tampering case. There's no evidence of it. But you know what's going on in the media is that Mr. Prieto and I are being vilified as being said that we are instigating this and we had our clients alter the computer.
Yeah, with
That's
that
what's out there. Imagine now we have to try to defend ourselves from what's going on. So we can't control what the media says, but as he said, we have to be able to respond. And so, you know, we have a motion to compel, which I know we just filed it last night based upon what's going on in the new thing. You probably don't, and they haven't had a chance to respond. We're going to ask you to try to put it on as soon as possible next week because our whole text communications were reviewed and it is our whole defense laid out in the text communications, which were subject to this new charge. That's how the whole case started with this new offense. It's based upon reading work product that we've had. And so now I don't know who has read the text from there. We're going to ask the court to do a protective order because God forbid, God forbid that discovery comes out and now they can Chapter 119 request all of our text messages. But there's a lot of issues to deal with. As you can see, it's not your normal case. So we are just making sure we counter.
So let me real quick. So first thing that she mentions is the fact that there are people out there that are vilifying them and saying that that the attorneys are trying to instigate tampering of evidence, which I don't like. I don't like seeing that. I have not seen anything that suggests that. Even with the detail of the Clenneys handing over the laptop to the defense attorneys, that happens all the time. That happens all the time where your client, gets custody of some sort of an item that is either something that they shouldn't have or something that, technically belongs to someone else, but for safety reasons, they have taken custody of it and they want to give it over to the attorney. That stuff happens in a lot of cases. So the fact that the attorneys then had access, or then had custody of the laptop does not mean that they are then somehow implicated in some sort of like evidence tampering issue. So I want to make that pretty clear. And the other thing that she gets into is that now, so she references a whole new motion to compel, which they're not going to be able to really dig into in this hearing. That's going to be on February 16th, where they're going to get into. That's going to be super spicy too, where it's going to be about these communications, these text messages, where she says that they have laid out their entire defense strategy in text message. First of all, I have never, I have, given my phone number to clients before, and, had communications, had correspondences with them, via text message and whatnot. But, um, y- laying out your entire case strategy via text message is just, I don't know. I mean, maybe that's just the way that they sort of fly in this particular firm, but I don't know. It makes me so uncomfortable. It makes me so uncomfortable to have given all of that by text message, to your client. Um, but yeah, I don't like it. But also, they are getting into now questions about attorney client privilege and attorney work product immunity. Yeah, Lupe, you're right to have questions about this. Work product communications with the parents, because, you know, people have an understanding that attorney client privilege, generally speaking, is between the attorney and the client. There are ways in which you include more people. For example, the people that work for the firm and that are communicating with the client for the purposes of representing them, whether it's litigation or a transactional issue. So, like those people are kind of covered under that umbrella. But when it comes to the client side, there are some exceptions as to like who counts as the client. The defense is going to have to really argue their case for why the father of the client should also be under that umbrella as like a client/client adjacent person. That's going to be a tough argument, because to me, as a default matter, that sounds like a communication, a privileged communication, which is then becomes a voluntary waiver by virtue of a third party communication. As soon as you have a third person in that conversation, it's no longer privileged. Whether or not the father fits into that, or whether or not his presence then waives that privilege, is a huge, huge, huge risk that the defense has right now. That I mean, they may have just made a huge waiver of this stuff. Okay, let's continue.
Calendared this only to make sure that we're not being prevented from being able to vigorously defend our client. It appears that Mr. Quinnen is saying he's not preventing it, so I think there may be no issues.
Okay, let's.
Can I address one of the concerns the court had?
Sure.
Well,
Might have been where I was going anyway, but go ahead.
yeah, so the docuseries, I can tell the court, yes, we were approached and interviews were had. We were approached because somebody wanted to put a neutral message out there to get.
When he says neutral, I don't know if he's saying that he was told that it would be neutral, or he assumed it was neutral, or he was assured it was neutral, but or if he somehow concluded that the result is it's neutral. I don't know, but the way that he said that just made me kind of smirk a little bit.
Both sides, not just the let's call it the crazy elevator video side. They've contacted us to put out a neutral documentary about what the family perceives is going on here, and the evidence that the state already put out in the public. There's nothing there that the state didn't already put out through their complete.
Choose your words carefully.
Yes, they put everything on the table, and it was a buffet for the media. And that buffet is still it's stacked with food, a never-ending supply of food. Another video produced by the civil attorneys, who, by the way, were on court TV this morning, talking about defense counsel, talking about the video they released, I think, a week and a half ago. So Judge, in my response, I cited the rules of professional responsibility. The model rule talks about this type of thing, that I am entitled to push back against the narrative that has been put out there, and I'm not saying the state is the ones telling the media, hey, have this narrative, but they're getting information piecemeal, as Ms. Puglisi says, these little snippets in time, and they are going to characterize them, demonize them, not the state, the media, as however they see fit, that creates the clicks on the websites, that creates more media attention.
Fair enough.
I believe the rules allow, our number one, the freedom of speech is obviously something that's implicated here, but more so to make sure my client gets the fair and impartial jury and trial. So,
Let me do this.
sure.
I want to take it back to what the standard is. So I don't know that either of you are asking anything particular of the court, maybe a protective order. It sounds like you had already asked for a protective order, maybe you're asking for one now. The standard here, again, is whether or not any extrajudicial statements are substantially likely to materially prejudice the trial, which I think I hear from both parties, we want to have a fair trial. Obviously, that's the goal of all of this, is to have a fair trial. And how do we do that in the presence of such media scrutiny? Are you both suggesting, or are neither of you suggesting, that we should somehow tailor this so that both sides are prevented from giving more media, attention or discovery? I just want to hear what it is that you guys are suggesting to me, because I hear from you that you were worried about this from the beginning and that you're worried about the media's response to the discovery that's been put out there. I hear you guys saying that you are worried about what defense is saying in the media about their case, about the victim in the case, and potentially whatever this docuseries is or will be. So what are you both suggesting and requesting from the court? I'm going to hear from the state person and about the defense.
Yes, Judge. So
I'm glad that she's like, okay, here's the standard. Now tell me what you guys want in relation to that standard. It's nice. I like her. I like her a lot.
regarding the respondent and the defendant's motion for protective order, the state actually believes the court should tailor. I think it's at the juncture where the court needs to tailor some kind of order over the parties.
I will say though, I mean, that super benefits the prosecution, because that doesn't change anything for them. They haven't made any statements to the press. They say that they don't intend to make any statements to the press. So they're like, yeah, go ahead and tailor it. That only impacts the defense. But the defense, to be fair, also has a certain obligation to their client to make statements to the press when this negative attention comes up, because some new piece of evidence comes out. And the new pieces of evidence are coming out because Florida has this very strong sunshine law, which allows the media basically very, very, very close access to this kind of information, unless there is a protective order over it for good reason, which, is always a possibility for any of these pieces of information. If there is something that is particularly sensitive, one or both sides can always request a protective order over a particular piece of evidence to make sure that it doesn't get made public. So that's always a possibility as well. But it is, I mean, it's totally predictable that the state would be like, yeah, of course, tailor something, tailor what we can say to the public, because it doesn't impact them at all.
Protective order that the defendant filed. The issue with that order, and the court well knows, the state's role is to function as administrative justice, and we could not go along with that as much as we'd love to. Limit our office because it's drained our resources. Our PIOs contact us to direct them to our evidence and discuss what's in our evidence. And that takes away from our time litigating this case and other cases as well as investigations. As much as we might love to do that, we cannot lawfully stand in this court and be like, yeah, Judge, seal all the discovery. We cannot, and that was our position then, it's our position now, and it will be our position always. And even if we had gone along with the defense's petition, Miami York would have appealed it, they would have won, and we'd be back at square.
I understand that wasn't what they were asking, but.
They were asking the court to in-camera micromanage discovery. That was their injunction. And that discovery was subject to public records. So it was the court superseding Chapter 119, which was the state's issue. There are collateral issues, but nonetheless. handling the case in Florida as opposed to federal court has, for a litany of cases, presented its challenges because we are the Sunshine State and sunshine is the best disinfectant. And so we, the state of Florida, and as a prosecutor in the state of Florida, we believe in the state and their right to scrutinize us, scrutinize the defense, scrutinize law enforcement, and scrutinize our case. We welcome that, and that's perfectly okay. The problem becomes, counsel gets a call. What do you have to say about this new video that was released by the attorneys for the family? No comment is easier than going on TV. Or, my client is innocent, we'll prove it at trial, no comment. Or the evidence will show my client is innocent. It does not necessitate outing a victim of sexual battery on television. It does not necessitate that. And certainly it's available in discovery, and certainly it's subject to public records. And just like the respondent leaked to a local news station regarding body camera from 48 hours before Christian's murder, and then gave an exclusive interview, frankly, that's subject to that too. We can't do anything about that. And the TMZ special, that bell is wrong. We can't do anything about that. The court does not have authority. And again, this is as a minister of justice and a prosecutor, the court cannot preclude TMZ from airing whatever footage they have. And that's where counsel's inappropriate actions require attention from this court. And that's why it's a petition to show cause in this form from the state, because his professional judgment, mind you, Your Honor, I've been an attorney for 7 years. I went straight to violent crimes, and I've been doing this for quite a long time. But counsel has been an attorney for over 20. And he well knows, especially his time as a prosecutor, and he well knows that he should have precluded that. As a matter of fact, the victim's family precluded TMZ interviews and specials. The victim's family was also approached, and they turned down interviews and interaction with TMZ.
All right, so what is it that you're requesting?
Oh yeah, just how neutral is this going to be if they're talking to the Clenney family, but the Obumseli family said, nope, we don't want to talk to you. So, yeah.
Your Honor, I subject all the parties to no public statements unless it's procedural. And the state would gladly abide. And I can't speak for counsel for the civil case.
I'm not gonna lie, I don't see the court going with that route. Maybe something to sort of split the baby between what the two sides are asking, but I don't see her going that extreme to say no statements unless it's procedural, because of the fact that the defense has this sort of responsibility on their end to combat any sort of potential prejudice to their client due to the publicity of what's coming out with the media.
Jurisdiction, I don't know if the respondent represents the defendant in the civil case, but a similar remedy can be sought in the civil case.
That's the problem though, judges, is you can't preclude the civil lawyers, you can't preclude the media from speaking. The train has left the.
She also doesn't, that's a very interesting point. The judge does not have jurisdiction over the civil attorneys. The Obumseli estate representative is the one who's been leaking a number of audios and videos. So she can't control them. So that kind of binds the defense in a way that they're not able to talk publicly about the case, but then the civil attorneys can talk publicly about the case. I have no idea who is representing Courtney Clenney on the civil side, but it seems that they are much less publicly active or vocal, or maybe I just haven't seen those interviews or something. But that does put the defense attorneys here in a difficult position when the civil attorneys are still able to speak freely on the case, and they can't respond then to the things that are happening because they can only talk about procedure.
Station, and it's now too late for us
and also yet another metaphor. The train has left the station.
Prevent that. I mean, I'm not really going to get into much about the outing the victim as a sexual victim. It was taken out of context. We've explained it. There was no there was no intent to try to shame anybody here. But we can't simply say, no comment, we're taking our client to trial, we think she's innocent, because that's just not good enough. It doesn't stop the media from continually, every single day this is on TV, on court TV, they're constantly reporting on it. And so
Well-
we have to be able to speak up at this point.
They can be reporting on it. They can be actively reporting on it every single day. But if their reporting is not causing, substantial prejudice to your client, that doesn't require you to respond. What would require you to respond is if that prejudice is resulting from that reporting.
And respond. Now, I understand that those comments need to be ethically made and done professionally, but we can't be prevented, or we should not be prevented from making comments at this time, because it's not just, and I'm not saying the state makes comments, because they don't, it doesn't come from them. It comes from others. And unfortunately, I don't think the court can stop that happening. And until the court does have that jurisdiction to stop the media from actually speaking, then I don't think we have any remedy.
Judge, if I may make one comment. So the issue here is we're also still before a lot of different evidentiary motions. There's going to be a lot of things that may be allowed in, that may not. The problem is when comments are being made about things that will not be coming into the trial, there may be jurors who are listening to these interviews. They're going to hear this and then look and expect it. And that's the problem.
Yeah, this is the issue that I have about the issue of materially prejudicing, they're being material prejudice to us getting a fair trial. Some things I think, no, it's not an issue. A lot of the stuff, things at the ARC hearing, those have nothing to do with us getting a fair trial. The issue becomes when you're having a docuseries where you are allegedly putting forward, purported evidence and witness statements prior to us getting to any of these evidentiary hearings or getting to trial. I think that you come a lot closer to the standard. And I think that you do come a lot closer to potentially prejudicing a fair trial. And that's what I want to prevent. That is my jurisdiction, is to make sure that I am doing what I can to make sure that Ms. Clenney has a fair trial, to make sure that the state has a fair trial, and to make sure that it hasn't completely been tried in the court of public opinion before we get here with a lot of evidence out there that's not going to be necessarily evidence that comes in either at the evidentiary hearings or at trial. So that is my concern.
But what happens with the discovery that is already in the possession of the media through Chapter 119 that won't necessarily be admissible in trial? Because we all know there's a lot of evidence that doesn't actually get admitted, but they are already showing those things in the media. And so those people you're talking about are seeing those things.
I think that those are, listen, I'm not saying that you're wrong about it being unfortunate fortunate or unfortunate, the reality is that we are a sunshine law state, and that we do have a very wide, there's very wide latitude given to what people can request with regard to the discovery in this case. What I can prevent on that or not, I don't know that I can. I think that that's something separate. But again, I agree with you that all of that's been taken by the media, and that everybody knows, everybody across the world, I think, if they're interested, knows, what the potential discovery is in this case. But the question is there anything that needs to happen now, given the fact that we do have that wide latitude with our sunshine laws, to try to make sure that we are doing as much as we can to make sure that we are going to have a fair trial. And whether or not comments on either side, or whether further interviews, which aren't subject to a sunshine law, the interviews don't have anything to do with sunshine law. They don't have anything to do with the ability of the public to get the evidence in the case, to get the discovery. That's not sunshine law. That is something that I do consider.
That's First Amendment, though, Judge.
Some of
That's
it
what
is,
it is.
but all the case law has to do with, how the First Amendment abuts narrowly tailoring any sort of restrictions on the First Amendment. You absolutely do have, First Amendment rights, and I think that there has been a lot of case law that has struck down restrictions on that First Amendment right. But there has also been case law that has upheld that. when it is narrowly tailored and when it's done correctly to preserve the fairness of your defendant's right to a fair trial and the state's right to.
So what she's getting at is that there is a way to set up rules on their speech that is narrowly tailored to getting a fair trial. Narrowly tailored is a buzzword for a particular standard, which is the most difficult standard to meet when it comes to rules on speech. Remember, there's like multiple different tiered levels as to rules on various constitutional rights, but First Amendment is usually one of the biggest ones, one of the strongest ones to invoke. So the judge here is saying, like, hey, look, First Amendment is a First Amendment, but there also can be rules that are put in place that restrict someone's First Amendment rights, so long as they're narrowly tailored to a compelling government interest. Such as maintaining a fair trial. Then that's going to be okay.
So that's what I want to hear from you is why it is that you believe that you should be able to, do this docuseries, that you should be able to make all these comments, and why you believe that that is not going to materially prejudice the trial in this case.
Judge, again, the state let the toothpaste out of the tube. It cannot be stuffed back in by Your Honor, by myself, or the state now, perhaps.
How much toothpaste? Did he just go to the dentist? Just like did he just go for a tooth cleaning? Maybe a root canal or something, and he that's why this keeps coming up.
Hindsight, could have had a filter team going through discovery, and yes, it would have been more work for everyone, but that would have prevented us. But that's water under the bridge. At this stage, I'm asking the court to take no action on
There's another metaphor. That's water under the bridge. How many metaphors can we get in this hearing?
this petition, deny it outright, because we have to, when more discovery comes out, we have to have the ability to push back. So, for example, Court TV calls us almost twice a week, and we don't go on very often. When we do go on, it's because they had a panel of experts analyzing video and commenting about what these quote-unquote experts think the video shows.
Right.
And that is improper for us to remain silent about. For example, the elevator video. Nobody talks about how that elevator video, the elevator goes directly into the client's apartment. Nobody talks about this gentleman having the only fob. And if we are not able to push back.
This is interesting because it's like it seems like that elevator video is really, really bothersome for them because he's mentioned it twice in this hearing, and now he's getting into and again he knows very well that the media is watching this right now. He knows that people are going to be commenting on this hearing. He knows, maybe even channels like this one, are going to be commenting on this, picking it apart and pausing and giving commentary. I mean, so the fact that he's like there's added context that they don't give when they put out a video like that is, for example, that elevator leads directly into their apartment. There's no hallway. It's just their living room that it leads to. And he just also made the allegation that Christian Obumseli had the only key fob to it. So in other words, in order to get to that level, you've got to swipe your key fob to allow you access into that level. And so that seems to indicate some sort of like level of control or something. I don't know, but it's interesting that he's putting this out there.
At the level that we've been pushing back against the media mischaracterizing the state's discovery, that will materially prejudice our client. And I haven't heard any, Judge, we presented at our motion to get some type of limit on or filter process for the discovery in this case. We had empirical data of the number of hits that the elevator video got. We had our IT expert conduct searches, and we gave the court empirical data of how many people were looking at this. The Miami Herald came back and said, we only got 2,000 clicks when there were millions, too bad for the Herald, but there were millions nationwide. The state has not presented to this court any empirical data about who's even watching these interviews on Court TV. So at this stage, I'm asking the court to deny it, not impose
There are people like us are watching those interviews on Court TV. Thank you. Be respectful.
any type of restrictions upon the defense. We think that what we've put out there is a counter narrative to mischaracterization of the state's discovery that we're not materially prejudicing anyone, any potential jurors, and there's no substantial likelihood of that. The substantial likelihood already occurred when the state just dropped every piece of evidence out there, whether admissible or not, for the consuming media, the media to consume it and digest it and then spin it however they want. We have to push back, and I think the case law supports that the court take no action this time.
And we're doing it consistently with the First Amendment.
Judge, may I reply?
Yes, briefly.
Yes. Counsel's last words were, we are obligated to put out a counter narrative. The premise of that statement is, I want to try this in the court of public opinion. To put out a counter narrative, there must be an original narrative. And to put out a counter narrative against the state, which is done in a trial, it's in court. The state has not put out any narrative. The state just produces evidence. We do not release statements. We speak in court. A person obtaining any sort of evidence, such as autopsy photos, and mischaracterizing that autopsy photo, is their right as a citizen in Florida, period. We cannot control how people misperceive things. We cannot control how people misdirect things. Neither can counsel to this point, and we can see that. But again, no one from the state is trying to try this in the court of public opinion. And the defendant is trying, more specifically the respondent, is trying to taint the panel before it gets here. That's the particular problem. People without credibility on the internet making wild accusations, wild statements on both sides, because it's not only that's the respondent and the defendant, have no basis being validated by any of the litigants, and particularly counsel. And that's why the court should impose, at this point, the only thing that's going to limit the prejudice for the immediate problems, because I understand from the most recent TMZ posting is that this special is airing a week from next Monday, is time, which is a delay. And if the court recalls the last setting, the state said, you know, we're concerned about getting dumped a bunch of witnesses and then a speedy demand. You know, that's just not saying in this case, I'm saying that's a constant concern for litigants across the board. And that's a problem, is that the only remedy at this juncture, particularly with an impending docuseries, is time. So if the defendant and the respondent chose to file a speedy demand so that they can try this case in the wake of this directed, at least based off of the emails that we received, the courts received, a perspective-based docuseries, they could do that, and the state is left without remedy. And that's the particular problem. The court needs to resolve it now, so that with time, the roiling boil reduces to a simmer. And the media can do whatever they want, that's their problem. And they can air and say whatever they want, that's their problem. But the litigants have no basis in saying anything to the media, period. The litigants should only speak in court. And that's what the state has done, and that's what the court asks to impose, consistent with the Polito.
Judge, I would just say that the First Amendment has a very high standard, and the state has not shown any evidence to support that speaking to the media will affect the jury pool. Your Honor even said, if this docuseries, we don't know. And unless there's data or evidence to support it, it cannot surpass the First Amendment right.
And Judge, we are, it's on the record. Ms. Puglisi and I said it last in the court. We are not filing, if the state's concern is we're trying to try this in the wake of we are not filing a speedy demand. It's on the record. I stand by that. Ms. Puglisi stands by it, and we stand by our reputations in defending our client.
Judge, I have one last comment. And it actually goes to a further request from the state. So as counsel had mentioned, the fact of they had to put their narrative on, say, the elevator video. what the attorneys say, and we all know this, what the attorneys say in trial is not evidence. That specific narrative would have to come from his client if she so chooses to testify in a trial. The reality is this is where we run into problems with these interviews for this TMZ program. Now, obviously, Your Honor may not have jurisdiction over TMZ, but Your Honor does have jurisdiction over the parties here. My understanding is you have to give permission to publish anybody's statement in any of these documentaries, and I believe Your Honor could put in an order to ask and order the defense to not authorize TMZ to post their statements in that, that documentary. And I think
That's an interesting request. That's an interesting. He basically said, he's like, look, the judge can't tell TMZ what to publish, what not to publish, right? Because that's a First Amendment right. TMZ has the right to publish what they want to publish. However, the statements given by the attorneys in that docuseries were given, or they can only appear in the documentary because those attorneys gave permission to use their likeness, to use their statements. That can also be withdrawn. So what he's saying here is, Your Honor, you can also basically require these attorneys to withdraw their consent to be part of this docuseries, so that TMZ essentially is required to omit their statements. And that way, there's statements by all these other people, but just not the attorneys.
that is the appropriate remedy here.
The court could order the parties to revoke their release.
Correct.
Their press release, their release for the hearing. Particularly within the Toledo.
Okay, I'm going to take all this into consideration. When did you say that you thought that this was?
According to the TMZ snippet from yesterday, it was a week from Monday, this coming Monday. So whether that's still the case or I misheard, Judge, I can find what I saw yesterday and send it to the court.
Monday the 12th, we confirmed that.
So I'm gonna have a order on all this by Tuesday. Okay.
Judge, can we talk about, I'm sorry, that was another matter, so can
Okay, so
we,
for this,
Before she gets into that, so I don't know if you guys heard it, but the judge said that she's going to try to have an order on this issue today. So we might have something to talk about tomorrow, because depending on when that order comes out on it, I don't know. We'll see.
I have an order on for Tuesday. If you want to give me a proposed order on the motion to compel the evidence as we discussed today, that would be great. I will draft my own order on this. Yes.
can we please next week schedule a hearing on the defendant's motion to compel and request for evidentiary hearing? It was filed yesterday, so I know you don't have a copy. We can forward you a copy to Chambers, so you'll have it. But it obviously deals with a lot of sensitive information. One of the things I'd like to at least know right now is, are Mr. Prieto and I, do we have our phones being recorded, our conversations recorded?
So, you'll give me a copy of yours. State, did you say that you had already filed another motion to compel, or?
No, Judge.
In response to their motion?
Yes, so the court, I raised today that Mr. Clenney is listed witness by the defense. The state is entitled, just like the defense would be, to memorialize statements by a witness in the case. They have no obligation to list the witness. So if he had not been listed, they would have an obligation to provide his statement. But they are in possession of statements by him.
Can you get anything that you think that you are entitled to in a motion by tomorrow?
Judge, I will additionally say though, I don't think we can hear that motion until after, because he is because he has a charge now. He's going to have a lawyer, and
Yeah, so, and that's what I was gonna say, Judge, and I think that matters also, the collateral is related to the defendant's motion to compel last night. So, I think what would be wise, just to evaluate some drafting time and how long it would take to respond, we could respond to their motion to compel and include within our response what we are compelling from the defense regarding Mr. Clenney. if the court follows me, I'm sorry.
And Judge, I want to caution the state, or if you can caution the state, part of what we're seeking is disclosure by the state of what we consider to be either attorney-client or work product
This
communications.
is interesting.
Part of what you're seeking?
Yes, because the state is in possession of our private communications.
Yikes.
If the state is going to be filing any kinds of responses attaching these communications, again, they're letting the toothpaste out of the tube. It needs to be filed under seal.
So much
Don't
toothpaste.
attach it.
Judge, we've also made a lot of these communications available to defense. It's over a terabyte of information.
Over a
We will have
terabyte.
to work with defense and communicate to get a device from them to be able to put all of these on. That being said, we're going to tell our public records people to not release without further order from you regarding the,
Privileged information, yes.
Correct.
Yes, Judge. So that's going to be part of litigation is whether voluntary disclosures to third parties are privileged for client conversations.
Or work product.
Again, voluntary.
Which is, that's what what I said before, is that there is a distinct possibility that privilege has been destroyed by including Kim Clenney in the texting thread between Courtney Clenney and Frank Prieto. So that's potentially a huge, huge, huge issue for the defense. A lot of toothpaste.
we'll wait for your order.
Okay, so Tuesday, I'm going to respond to this. If you could, I'm gonna look for a copy of your motion. If you could reply by next Tuesday, does that give you enough time?
Next Tuesday is the coming Tuesday.
Yeah, I mean, my concern is that you seem to have some urgency here about obviously the non-disclosure of what you consider privileged.
Right, Judge, because we don't know how the filter team was. Are we going to need to move to recuse the entire state attorney's office for not following proper protocol, for searching into communications that are privileged? There's a lot of issues here, but
The likelihood that every single attorney in the state attorney's office has looked through potentially privileged communications between these attorneys and Kim Clenney and others is extremely low. I mean, it's a very large office. So recusing the entire state attorney's office seems a little bit of a stretch. But maybe there are some people that saw it that shouldn't have seen it, in which case then they would be conflicted out of the case potentially.
really want to know, because Mr. Prato and I were named as principals in their warrant. Are we being recorded, our conversations? Can they at least answer that today?
Okay, so that's the urgency of what.
Judge, there are no wiretaps. These were pursuant to 2 warrants that we provided counsel and are part of the public record.
And can we also make it clear, since the media is listening, that this is not a tampering case? There's no allegation, at this time at least, there's no allegation that anything was done to this computer to tamper with it.
We only recovered the laptop on Tuesday that should have never been in the defendant's possession to begin with.
That's not.
That's not true.
All right, so here's what we're gonna do. It sounds like you need more time to respond. to
Okay,
that.
so I mean, since the media is here and they are listening, this was not a tampering case. Okay, all right, we've made that very clear here. Oh man, there's just drama. You can tell that they are definitely fighting tooth and nail behind the scenes with these phone calls and emails back and forth between prosecution and defense. But it sounds like, so the defense thought that they were being wiretapped, which would be 100% not okay. But what the prosecution said is that no, this was all pursuant to a warrant, which we provided over to you guys. So they had noticed that the prosecution was going to, from what it sounds like, they had notice of the fact that the prosecution was issuing a warrant, probably to the cell phone company, to get all of those text messages from Kim and Deborah Clenney's phones, and and that's how they got this information.
They have given me their assurances that you're not being recorded right now, which takes away that urgency.
Or any warrants being served on our iCloud accounts or any of our personal communication devices.
There have been no warrants served on anything regarding Mr. Prates or his Obumseli. The warrants have been served regarding Ms. Clenney's iCloud, Ms. Deborah Clenney's iCloud, Mr. Clenney's iCloud that was kind of commingled with Ms. Clenney's iCloud. That was served in November. We don't have any of those matters pending. There will be upcoming warrants on both of Mr. and Mrs. Clenney's iPhones. There is an upcoming warrant on Mr. Obumseli's laptop as well.
But not for counsel.
Well,
We have
that-
not sought any warrants or process on counsel.
The problem is there are work product, attorney-client communications
On there.
on their phones with a group chat.
So that's, again, voluntary disclosure to third parties.
We're not litigating that issue now. You can receive, the state can respond and
Here's what we're gonna
we'll
do.
argue with.
For
the
that, I'm
court.
gonna give you 2 weeks to respond to that. If there's some sort of emergency that comes up, or you believe that there's an emergency where you believe that something is going to be disclosed that you believe is privileged, come and bring it to my attention. I'm gonna put it on the state to do the same if you know that something is going to potentially be an issue. You gotta bring it to my attention. But right now, I'm gonna give you 2 weeks to respond to that. That doesn't take away the fact that I'm gonna have this order for you on Tuesday.
And lastly, Judge, related to that is, we'll be doing a motion to quash a subpoena. It was filed against our defense expert, and it's set for, or his interview with Ms. Hogue is set for the 9th, which is next week. So we'll be in the
You wanna do that
process.
on Tuesday as well?
Yes, Judge, we'll have that filed. I just wanted, because I know we may not hear it, but until that gets done, we would move to, hold off on any kind of interview. He is being represented by Jude Fecciadomo. So, but we believe, because it's our defense expert, that it's us who would be doing the motion to quash. So,
Just get it filed before the 9th and,
Yeah.
No, the 9th is the.
It's the date he's supposed to
This is
go.
For the subpoena.
He's supposed to go.
Okay, so if that happens, obviously you need to hold off on anything if there's a pending motion to quash.
Yes, sir.
All right, anything else for today?
Regarding that motion to quash, I will probably need 24 hours to reply.
I don't think that she's necessarily requiring a reply to it, she's just saying that.
He's not going to show up
Yeah,
for the
she's-
9th.
She's saying that that is going to be happening, so that interview is going to need to take place a different day.
Right.
If it happens.
That's it.
Okay.
And Your Honor, on Ms. Clenney's new case, on the arraignment date, since she has already been arraigned, could we waive her appearance for that February
Yes, that's
16th
fine.
date?
Yes. All right. Anything further? All right.
Nothing.
You can come in on Tuesday if you choose to, but I'll probably just e-file the order, so it doesn't, you don't have to come in. We can put it on for Tuesday just for my order, but just know that you don't have to be here for it. Okay?
Thank you, Judge.
Thank you, Judge.
I'm sorry, there was nothing further from the state, but the next thing would like to be.
Okay, recognizing
No.
that it, no?
Oh, I'm sorry.
Okay, recognizing that it doesn't have any, what's that?
No problem.
All right, thank you. All right, thank you all.
Okay. Cool. So that is the hearing. Like I said, a lot of spice, a lot of metaphors, a lot of toothpaste. We all have clean teeth now at this point, maybe. But there's a lot that's going on in this case. So this has been night as a one. We need a toothpaste emote now. We just might. We just might. Or maybe like a metaphor alert emote. So yeah, there are definitely things happening in this case. It'll be interesting to see. It's interesting because the next hearing is scheduled for the 16th. The 12th is when the docuseries is supposed to come out. But she said that she's planning to have a ruling on the issues related to the docuseries out sometime today. So we'll see. We'll see what happens. And if that gets reported on, who knows? But I'm very interested to see what she ends up deciding on that. But a lot of these other issues are going to be coming up on the 16th. I anticipate that they probably will have cameras in the courtroom for that hearing as well. And there's going to be so much spice. So anyway, so this has been absolutely fascinating. I feel like I've learned things going on in the case that I otherwise wouldn't have known about, otherwise wouldn't have realized. A number of these behind the scenes sort of issues. So anyway, but I hope you guys enjoyed it. If you did, please do like the stream before you head out. Thank you so much for watching with me. Thank you to the folks that are joining in, liking the video, commenting in the chat, commenting in the comment section, whether you're watching live or on replay, whether you are actively engaging or just lurking. I appreciate every single one of you. So with that, I'm going to end the stream about there, and I'll see you guys in the next video. Thanks, guys.